turn to the last case on this morning's docket. That is case number 102904, Damon Vontress v. State of Kansas.
May it please the Court, Michael Whalen on behalf of the appellant Damon Vontress, and with the Chief Justice's permission, I would ask to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you, Your Honor. In Mr. Vontress' case, the Court of Appeals created, in reliance upon Tony v. State, a non-statutory requirement for pleadings in KSA 601507 cases when dealing with an out-of-time filing. Very succinctly, Tony has been used since I filed the petition for this case in February of 2011. There have been at least 8 other decisions by the Court of Appeals in reliance upon this interpretation of Tony and Vontress. And I have, I believe, another 10 to 15 cases all making the same arguments. The import of this is the fact that the Vontress case is the only published case that has given this standard in dealing with out-of-time filings for those that go beyond the 1-year statute of limitations under KSA subsection F. The problems with this are multiple. Number one, we have a very unambiguous statutory language here that the court may extend the time limitations in order to prevent a manifest injustice. There is no subsection A that says, in the course of your pleadings, if you happen to be filing beyond your 1-year time, you must show the reasons why or the manifest injustice that prevented you from filing within the 1-year time limitations. And that's the order that Tony and the Court of Appeals in this case placed upon inmates and persons wishing to seek review under 1507. It's rife with problems. Number one, because it's not there, it doesn't exist statutorily as a requirement, there's no notice.
So you're arguing here today that the problem with the manifest injustice is not that it's been applied to mean manifestly unjust, that there were reasons for the delay, that it would be manifestly unjust because the delay was excused versus manifest injustice because of the merits of the case.
It's a difficult distinction in that I think there are times when an argument can be made. I had a similar situation with a client who hired out-of-town counsel to do a 1507 for him. 6 years pass, no action is taken. The attorney that's representing him passes away. Another partner in the firm says, we told you a long time ago you had nothing. The client speaks to an attorney in Kansas City, an appellate attorney who says, you're out of time, you have no hope. Our argument to the district court, and when I took the case over, was it would be manifestly unjust for this court to not hear this case because he's done everything that he could to try and pursue the issues. So there,
in a timely way.
In a timely fashion.
That's the problem. A lot of times manifest injustice arising out of the time limit overlaps with the manifest injustice that arises out of the merits.
Correct. But the distinction, I think, is the way that it's put forth in Tony and the way it's applied in Vontress, in that they're saying you must show the reason why you did not file in a timely manner. But that's not what the statute addresses. The statute addresses the extension of the time limitation to prevent a manifest injustice.
If it has to be the merits, if it has to be manifest injustice arising out of the merits, doesn't that erase the time limit? Because the more vague the motion, the more likely you are to be able to proceed. That's the problem here, isn't it?
There is a difficulty there, but once again, I think the difficulty lies with the legislature. They decided that time limitations were necessary, and that's within their purview. And they gave a means for the courts to be able to look at the cases and issues that came before them, which is to prevent a manifest injustice. It's still, I think, discretionary to the district courts to make that determination. I think it's improper for the Court of Appeals to define it as, here's what you must plead in your petition. Because if we take a look at, under this court, Supreme Court Rule 183, subsection E, there was a mandate given to the Judicial Commission to produce a form for inmates to fill out for 60-1507 matters. And in the instructions to that document, it states, for this motion to be considered by the district court, you must submit it in writing, set forth concise answers to each applicable question, and sign under penalty of perjury. That's the extent of it. Within the 6 pages of the document that is provided to inmates by this court, and by order of this court, there is nothing in the information given to them, one, about the time limitations. There's nothing in there about the requirements for filing a successive motion. And there certainly is nothing mentioned about the requirement under Vontress to expressly plead the reasons why you are filing out of time.
Counsel, I'd like to ask you to respond to a question about KSA 6206B, part of our Code of Civil Procedure, but since a 60-1507 is, of course, a civil proceeding, the civil code would apply. Would you agree with that?
Yes, Your Honor.
Okay.
Although this court has found that not all rules do apply, and that 60-1507 actions are a unique creature, and we haven't had the relation back. This court has amended how we do relation back. So I guess I can't say straight yes, all the rules of civil procedure, but depending upon your question.
I'll note your disclaimer for the record.
Thank you, Your Honor.
Just see if you can answer this question. Assuming that this would apply, it states that when by this chapter, Chapter 60, an act is required or allowed to be done at or within a specified time, the judge, for cause shown, may at any time in the judge's discretion, upon motion made after the expiration of the specified period, permit the act to be done, where the failure to act was a result of excusable neglect. And then that statute goes on to say, but it may not extend the time for taking any action, and it lists 3 or 4 statutes in their subsections. 60-1507 is not one of those exceptions. So I'm asking you, apparently it sounds like for the first time, to tell me whether 6206B would have any impact on this case whatsoever.
I think that it should. It's not so different from the manifest injustice standard in that it's discretionary to the court. I guess it sets a different standard of there's a required showing of excusable neglect. And maybe that's the point the court is getting to, that someone filing out of time is then going to be required to plead excusable neglect under 206. I think what this 1507 statute gives individuals the opportunity is to plead or show to the court through the course of their filing whether or not they meet the manifest injustice standard.
So does the requirement under 1507F2 of showing manifest injustice trump the requirement of 206B? Or are they both have to be shown by the petitioner? Or does 206B trump 1507F2?
I would say that I'm not quite sure how that interplay would work. The practical difficulty that
isn't one more specific than the other? Isn't one more specific than the other? 1507
If
is
we're looking at
specific.
specific versus general, I think we are, because it deals directly with the type of issue that's being raised and the standard that's being applied. But I think one of the fundamental flaws we then have as well, if we look at it that 6206 should be applicable, the point that I was trying to get to before is these forms that we're giving our indigent clients or persons who are filing, none of this information is available to them. And we can give a little more forgiveness for at least the requirement of trying to prevent a manifest injustice is in the statutes, and we're giving them notice of that statutorily. But if they are required to plead, we can never forget the fact that the majority of my clients and persons who are filing these are illiterate, mentally ill, not schooled in the law, are imprisoned, have limited access. The law libraries in the prisons are updated once a year. Legal Services for Prisoners has 10 attorneys for, I believe, 9,000 inmates currently. There's also precedent of this court to liberally construe pro se filings, and in particular in the 1507 realm. If we are making, it's kind of a double secret probation. We're going to tell ourselves in case law, you have to plead why you're late filing. But it's not part of the statute, and it's not a part of the forms that we're giving you. But if you don't do it, you're out. And you lose your opportunity for access to the courts. And so we wind up in limitations, and I think a due process issue and a constitutional issue of access to the courts by having requirements out there that are not statutorily made, that are judicially created, and are not proper notices and being given to those that it affects the most.
Well, let's go back to that last point. I believe I recited to you the language from 206B, which is a statutory requirement for your desiring to file something at a time. You have to persuade the court in the court's discretion that excusable neglect was the cause. So let me move on to the suggestion floated by my colleague Justice Beyer, and that would be that 1507F2 is more specific. It deals with the habeas corpus, and therefore it would trump 206B. Holding that thought, I'd ask you to consider what do we do about the fact that in 206B it very specifically sets out a few exceptions to its requirement, none of which is 1507. Do you have a response to that?
Well, we go by the standard of we presume the legislature doesn't make meaningless law, and we presume that. And therefore, the fact that they excluded specific statutes and didn't include 1507, you can make the step there that 206 should be applicable to all of those because it wasn't specifically excluded. I think there's a point there. But we are then through Supreme Court Rule 183E and the forms that we're giving these people, I think kind of neglecting the information that we're giving to them, because there is none of that information in the forms and questions that are provided. And again, I think we get back to excusable neglect. None of these persons have a right to an attorney to assist them with anything that they are doing. It is maybe 1 in 200 that actually has family that gets some sort of legal assistance. They are doing this on their own with no training, no education, and at this point, no psych services, no rehabilitation services, no assistance at all from the Kansas Department of Corrections. What they have is a form that's been promulgated by the Judicial Commission to fill out and send in. We expect a lot. And without more information or more than this simple instruction, because the instruction to this says, if you want your case to be considered, fill it out in writing, be concise, and answer all the questions. There's no reference to any of these other necessary pleadings. And I think that, although, granted, this is a little beyond what we dealt with the Court of Appeals, This is actually inspired by a dissent by Justice Lieben in Reich versus State, which came out last September, that he mentioned the idea that there's no notice of any of this information on any of the forms that have been provided by this court. As applies specifically to this case, again, if we look at KSA 206 and the need for separate pleadings and a showing of excusable neglect, I think it's different from what the Court of Appeals has interpreted and how they've applied Tony. That hasn't been a requirement previously. It could be, I would think that if that is going to be the standard and the requirement that this court decides, that it should be prospective only and that there should be notice, and I would think information included on forms in the future if they're ever amended and re-provided. I guess maybe that would be my suggestion in the answer, Your Honor. It's one that's, I can see where it would be applicable, Chief Justice. It kind of makes sense in that manner, but it's never been enforced or provided that way, and that's still not what the interpretation of Tony and the Court of Appeals and Vontress was. But I would think if that is going to be the issue or the proper manner, that it would be best to come from this court. If there's nothing further, I believe I'm well out of time.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Counsel, before you start your prepared remarks, I wonder if we could get to that issue that you've been listening to for the last 10 or 15 minutes. Have you given any thought to how or whether 6206B might apply to a 1507?
Before that, I would announce, may it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. I am not familiar with 6206B, however, and did not look at that prior to this. But from what you recited and the fact that it does not specifically exclude 1507 from its purview, I believe it could be read with 1507 to indicate that a defendant needs to plead, if his motion is untimely, a defendant needs to plead why was it untimely. There needs to be some sort of showing, otherwise how is the court going to determine if the time limit should be extended to prevent a manifest injustice? Is
1507F a statute of limitations?
I would believe it is a limitation.
Then what about 6208 that makes a statute of limitations an affirmative defense that must be pled or it's deemed waived? And what about 6212A that says defendant must serve an answer within 21 days? So really the state must file an answer and affirmatively plead statute of limitations. And why is it then incumbent on a movant to make your affirmative defense for you?
First of all, I will again state that I have not reviewed those civil statutes for today because that was not a part of this. However, as Mr. Whalen indicated, 601507 has been determined by this court to be a special animal. Yes, it falls under the civil code, but again, not everything applies. Furthermore, we do answer. Excuse me?
Just whatever we want to apply. There hasn't been any definitive indication that I've seen of which parts of Chapter 60 apply and which don't. It's been on an ad hoc basis, hasn't it? As the issue comes up, we decide whether to apply it or not.
Again, because that was not the focus here, I can't speak to that, but I will speak to the fact that you said an answer should be filed, and I can speak to Sedgwick County, and we do file answers in response to the 1507 motions that are filed by defendants, and if an issue or a motion is untimely or successive, we do plead that in our answer, and that was done here before the district court. We pled in our answer that this was an untimely motion and that defendant had not given any excuse for his untimely filing. This was filed over 10 years after his conviction had been affirmed. And he gave no excuse for, had he been working on this, had something happened to keep him from being able to file. None of that was pled. Instead, his argument and the argument below was that it would be manifestly unjust to not review the merits of the claim.
Because he has merit to the claim. I mean, his argument below was entirely dependent on his view of the merits, right?
Yes.
Yeah.
Yes.
That's what I thought.
And it's our position here that there needs to be finality in the criminal process. And the intent of the legislature when they added this limitation to the 1507 statute was to bar stale claims. And essentially here, this would be a stale claim. And prior to this limitation being added to the statute, we did have to review stale claims, and the district court would have to review those. And then, they could wait 20, 30 years later, file their claim, and then you have to determine, we would argue, latches. This statute has given us the ability for there to be some sort of finality in the criminal proceeding, and this court has indicated that finality is necessary in the criminal proceeding. And there is a need for finality because who knows where the witnesses are. Victims need finality. Even the defendant and the state are entitled to a speedy resolution of criminal charges.
Counsel, I'd like to ask you the same question I asked opposing counsel, and that was under the assumption that 6206B would apply. If it does apply, what would a petitioner have to show in order to get an otherwise untimely petition filed and considered by the court on the merits? Would that petitioner have to demonstrate excusable neglect under 206B, and once that happened, the petitioner was allowed to file, or would the petitioner ignore 206B and simply show manifest injustice under 1507F2? And once that happened, it would be timely filed, or does it have to be both? Or do you have an opinion on that?
This is the way I would answer that. We know that from Easterwood versus State, this court noted that 60-1507 follows the language of a federal statute. And within that federal statute, 28 U.S.C. section 2255, a petitioner must show extraordinary circumstances to qualify for equitable tolling of a 1-year statute of limitations. And that extraordinary circumstances in Marsh versus Soares, which is a 10th Circuit opinion, was defined to be pled as an inmate needs to present that they, in that situation, diligently pursued his claims and demonstrated that the failure to timely file was caused by circumstances beyond his control. And I believe that is something similar here. That to show manifest injustice, you need to show extraordinary circumstances that you were attempting to get this motion here heard. Mr. Whalen gave an example of a different client who had an attorney, thought the attorney was handling his motion. Attorney dies. The partner says, sorry, you don't have anything. He goes to another attorney. He has been trying to get his claims heard in that situation. In this case, we have no indication that Mr. Vontress was trying to get his claims heard for the 10 years since his appeal, his direct appeal, was affirmed. We have no information, and I think that's what this court needs to look for, that there needs to be some sort of showing that they were trying to do something or something prevented them from doing that. And then because of that, it would be obviously unfair or shocking to the conscience to not hear the merits of their claim. And manifest injustice has not been defined in the realm of 1507, but in other situations, it has been defined to mean obviously unfair or shocking to the conscience. And here, looking at Mr. Vontress's motion, it is not obviously unfair or shocking to the conscience that his motion is not reviewed, because it is so far out of time. It is so stale, and he has said nothing to indicate why did it take so long to raise these claims that are purely attacking the constitutionality of the statutes regarding premeditation. This is not a situation where laws have changed and they changed on him. He, in his motion, cites case law that goes back to the 1800s. This is not something new. There is no manifest injustice here, and it is our position that there needs to be finality, and that is what this statute of limitations that was added to 1507 creates. And we have limitations in everything, and here we need to keep this limitation because the legislature wanted to bar stale claims, and that is what we have.
Of course, as I think one of my colleagues pointed out, or maybe it was opposing counsel, that's not the language of 1507 F2. It just says manifest injustice, correct? So
I would
as I
agree with
understand
that.
it, you're asking us to accept the federal court's interpretation of their own habeas corpus statute and ignore the plain language of our own?
Well, this court, as I said, did indicate in Easterwood that this statute, this 1507, follows the language of the federal statute. That is what this court has indicated. And within that federal statute, they indicate what it takes in their situation to, and they use the word
Isn't the
toll.
language different? You said it was extraordinary
It is
circumstances.
different. It is different.
So
It is not
obviously
exactly the same.
In that aspect, it doesn't follow the language.
Correct.
Yeah.
Correct.
So in response to my earlier question, if what you say is true and that we should be following the way of the federal courts, what do we do with 206B?
Again, without studying 206B before coming today, I don't think I can give an educated answer to that, other than I still believe that it's possible that the two could be read together because it does not exclude 1507. You indicated that it excludes certain statutes, and it does not exclude 1507 from its application.
So if we read those two together, are you saying that both would be obstacles for a petitioner to reach if the petitioner had waited more than a year? So the petitioner would have to show excusable neglect for why it was late, and then manifest injustice is somehow a showing that he has a meritorious argument? Or how would those work?
I guess my position is that 206B gives an indication that they have to make a showing, and in that situation is excusable neglect. Here we clearly have a statute that talks about manifest injustice, and I guess when I say they need to be read together, it indicates that the defendant needs, or the respondent needs, to make a showing of some sort as to why it has taken so long, why his motion is untimely. And that, I guess, is my position on how you would read them together without studying 206B.
Well, as counsel indicated, why do we have, if we're going to use 206B on a situation like this where the person was basically out of time, why would the legislature talk about manifest injustice in 1507 F2? Because he suggests they don't have redundant or useless legislation.
I can't answer that without saying that clearly 1507 is more specific. It deals with a very specific type of motion. But again, even though it doesn't have an indication that it says can only be extended to prevent manifest injustice. Obviously, from that, a defendant needs to indicate something that the court can look at. Otherwise, if we are only going to look at the merits of a respondent's motion to determine whether or not there's manifest injustice, then a statute of limitations is unnecessary, because you would have to look at the claim to determine if something's untimely. Then if you decide, or if it's untimely, you have to look at the claim to determine if it's manifest injustice, not to extend the time limit. So you do that once. So then you say, okay, it would be manifestly unjust if we don't extend the time limit. You extend the time limit, and then you consider the merits a second time to determine is he entitled to an evidentiary hearing, or is he entitled to relief on his claim. The statute of limitation would have no effect. There would be no limitation. And I believe the legislature's focus here was finality and to bar stale claims that we do have in this situation. And it's our position that the district court's factual findings here, under the standard of review for a 1507, the district court's factual findings are supported by substantial competent evidence, and those findings are sufficient to support its conclusion of law. The motion here was untimely, and defendant made no showing of manifest injustice to support an extension of that time limit. And we would ask that the Court of Appeals and the district court be affirmed.
Let me just make sure I understand.
Yes.
So, boiled to its essence, your argument is that manifest injustice in 1507 refers specifically to the procedural delay, that the petitioner, or the movement should have to plead a reason for the delay that amounts to manifest injustice.
Yes, I believe they have to
It's a
give
procedural thing, not a merits thing. Because if it's a merits thing, then the statute of limitations is essentially swallowed.
right. Right. No.
So it's an exception from the ordinary civil rule, pointed out by my colleague Justice Johnson, that it's normally on the defendant to plead the statute of limitations as a defense, and that in an ordinary civil action, the plaintiff doesn't have an obligation to talk about the statute of limitations in the original pleading.
Yes, and I think the problem here is if they don't give a reason, or if they don't talk about, and you've seen these motions, I mean, they're not necessarily formal, they throw whatever out there, and that's fine, but because they are filed pro se, but if they don't give you some sort of indication as what has taken so long, why you should review the motion, then there is nothing to review other than the merits to determine manifest injustice. And if you're going to the merits, then there is no limitation.
I understand. Thank you.
Another possible interpretation would be that the legislature intended to impose a higher burden for relief if an action was more than 1 year after the appeal. And if that is a possibility in your mind, is there a difference in the standard a defendant would have in a timely 1507 in order to get relief? Is that equivalent to him establishing manifest injustice? In other words, is manifest justice the same standard or a higher standard in your view?
Then excusable neglect? Is that what you're...
Sure, I
No,
understand.
no, just on the merits. If on the merits, to get a relief, defendant has to show, the basis.
Right.
If we would say that what the legislature perhaps was trying to do was establish a different standard, did they accomplish that by saying manifest injustice would be the standard?
To determine if a untimely claim should be, if the timeliness should be extended.
Or just even if they're saying, we don't care that it's past a year, if the merits are so egregious that we see a manifest injustice if relief isn't granted.
The test
Is
for
that the
reversibility.
test for reversibility?
I don't think the legislature indicated that the review to determine if the timeliness could be extended points to the merits.
I know, but I'm asking you to just to go there with me, because if I'm going to buy, if I'm on this theory that what they really weren't creating a statute of limitations, they were creating a different standard of reversibility, perhaps a higher, and then I'm asking, did they accomplish that if that was their purpose? Or do we always say there's manifest injustice when we reverse on a 1507?
I'm not sure I follow that completely, but I don't think if that's what they were trying to do, and I don't believe, and it's not our position that's what they were trying to do. I don't think that's clear. I think it is a limitation to deal with the stale claims and to indicate that there is some finality and there needs to be some finality in the process. I don't think that's what they were doing. And I'm not sure that I really answered your question, but I'll have to think about that.
I think that's consistent with what you said before, that this is a procedural mechanism, not a merits-based standard.
It doesn't make sense to me to review the merits to determine if something should be excused for timeliness or not. You're going to do the whole process more than once, and then your limitation really doesn't matter, and that's what the Court of Appeals indicated in Tony. Essentially, if you do it that way, then there is no time limitation because you will always have to look to the merits. So,
Any further questions of counsel? Thank you, counsel.
thank you.
If we look at KSA 6206B, I would say that it's completely discretionary. I don't think it's mandatory for an extension of time to be granted by a court out of time in reading the language there, because it says, in general, when an act may or must be done within a specified time, the court may, for good cause, extend the time. It doesn't say this is the exclusive means or remedy for a court to extend time. It gives a basis and a means for doing so. And it kind of brings us back to F2 in that, or 1507 subsection F. Is this a time limitation? Necessarily. Because by adding the manifest injustice as an out, I mean, it's never been found that this is jurisdictionally a bar if you file on something outside of the 1 year time limitations. So it doesn't necessarily, and there's some unpublished Court of Appeals cases that have found that basically it's, I don't know, kind of a time guideline because it's not a set time to have something filed. And I think that goes with what Justice Luker, you were raising as far as, is this a requirement of additional, I guess, discretion or review by the court in looking at what's been submitted. But in thinking about it, and you may have made the statement, aren't we making a manifest injustice finding any time one of these cases is overturned? Because we have the Justice Stewart, I know it when I see it problem with manifest injustice. We don't have a definition. It's something shocking to the conscience. But it's not that far off from the same standard in order to show ineffective assistance of counsel and prejudice to the point that a different outcome would be probable. I mean, I don't know that our standards are that far off. Where it comes, I guess, is in the review process for an untimely filing is we start at that point, potentially, and maybe that's kind of what we're looking at. We do run into this being a different kind of dog because if you look at 1507 subsection A, there's no requirement that the state ever get notice of the filing of A 60-1507. it goes first to the court. The court then, only if it makes a finding that there are issues that cannot be resolved by a review of the files and et cetera of the case, the court then forwards and decides whether or not the state gets involved. So the affirmative defense, and I've used this argument, we've had a judge recently who's been using a checklist on cases that come in and saying successive, denied, successive, denied. You know, it's a 20-year-old case. Our argument on appeal is, well, it wasn't untimely because nobody brought it up. And there is some case law in 1507 realm that if it's not done as an affirmative defense. But here, unlike the Code of Civil Procedure, there's no requirement for a responsive pleading. In fact, the state may never get notice that there was a habeas petition filed because there's no requirement for that. The judges get to handle it independently. And this is part of where I think we have, these differences. And Justice Johnson, I think you're absolutely right. This has been an ad hoc approach in determining, based upon the language of 1507 itself and its own created, or I guess self-evident procedures that differ from the regular procedures under the Code of Civil Procedure, that we fill in gaps and try and fix things or make determinations, or not we, this court, as to how these cases are going to go and be handled. And that's kind of what we're dealing with here. And I think this is the issue, is ultimately how do we define and handle the manifest injustice standard as it relates to the timeliness issue. And I think we have to go back to what I said at the very beginning. It's plain, unambiguous language. That the question for the district court is, will it prevent a manifest injustice? That's the consideration, the only consideration given to the court by the legislature. And to expand that through judicial action, as my take on the Tony and Vontress decisions in the Court of Appeals, makes, it dilutes plain unambiguous language, and I think we should be grateful for that when we get it from the legislature. I think that it creates standards that are not then promulgated or made known to the individuals who are going to have to meet these standards, and yet who are never told of it. And I think for the most part that's what I have, unless the court has further questions.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes this morning's docket. The court is in recess until 9 o'clock tomorrow morning.